as ordered, and that was for community corrections, and they had been unable to verify her attendance at the Bear River treatment program in which she was to participate. Ms. Hall was then lodged in Kalkaska County on a warrant dated, I'm sorry, I don't know what the warrant was, or that's when she was arrested on March 13th of this year. All right, thank you very much. Mr. I should have counted. Also that on April 21st, 2026, Judge Corey Wiggins of the 84th District Court, operating by a state court administrator's order to allow him to appear and cover my docket while I was out of town, conducted an arraignment, and that's why we're here today. All right, Mr. Champion.
Your Honor, at the time of the arraignment, we did not have verification that Ms. Hall has completed her inpatient portion of the Great Lakes Recovery Center. Since then, or shortly, I think it was the very next day or that day, we did receive verification that she had completed on the program at New Hope House in Petoskey, and she had transitioned into the outpatient portion of the treatment program. However, when she did that, she did not sign up for the testing as required by her bond violations. Ms. Hall is aware of that and will be admitting responsibility for that.
All right. This court back on January 5th of this year signed an order releasing Ms. Hall on a PR bond to an inpatient treatment program. That was to begin on January 8th. That was the Women's New Hope House Residential Treatment Facility up in Sault Ste. Marie, which also has offices in, I believe, in Petoskey. And then on release, she was to report to community corrections. All right, Ms. Hall, please raise your hand to the best that you can. Let's switch hands. It's okay, everybody does it. You swear or affirm the information, testimony you're about to provide shall be the truth, the whole truth, nothing but the truth, ma'am?
Yes.
Thank you. All right, Ms. Hall, you do have the right to due process, which requires the court to, requires the prosecutor to produce some evidence to demonstrate that you had violated your bond. And that could be through a hearing. Now, that's not a trial. It's not proof beyond a reasonable doubt. And if you make an admission today, you won't have that hearing. Do you understand?
Yes.
And has anyone made any promises, threats, or inducements to force or compel you to admit to violating your bond today?
No.
All right, thank you. Is it true, Ms. Hall, that upon being released from the New Hope program, you failed to report to community corrections?
It is true, but I didn't understand that that's while I was still in treatment.
Mhm.
That's what I didn't understand that I had to do that then.
Okay. And so when did you get out of, was there a residential portion?
Yes,
And when did you get out of the residential portion?
I was there for 2 weeks.
And when you went there and got out in 2 weeks, had you successfully completed the program?
Yes,
And when you got out, where did you go?
I went to my address at 802 Fire Street.
Okay. And was there any outpatient or sober living program that was attached to the New Hope treatment?
I don't believe so.
Okay. All right. So, the court finds the defendant has violated her bond, specifically paragraph 7 on page 2 of the court's order dated January 5th of this year said, upon planned or actual departure from the treatment facility for any reason, the defendant and or the facility shall immediately notify community corrections and the public defender program. Also, is to comply with all other bond conditions. All right, so therefore the defendant is in violation of her bond. Have we already, no, she's awaiting sentencing but had pled.
She has blood, correct?
Yeah. Okay, so is she also being held, from what I understand on this other case up in Calcasieu, or what's happened with that now?
That was a fines and cost situation, and that has been resolved, Your Honor.
All right. Thank you. No, because the day is set for a bond hearing. I don't have a PSI here in front of me today. Is there anything we want to proceed with sentencing? I'm sure I could get a PSI.
We have no objection if the court wanted to do. We have the copy of the PSI.
All right. Miss Odell, do you have a copy I could review, or somebody? And Mr. Rickstrom, any objection to proceeding this?
I do not, Your Honor. For the record, on February 27th, we had gone through the PSI as a whole.
Yeah.
We were about ready to sentence. I only have my copy, but
Okay. All right. I've got that. Miss Odell, are you gonna, well, it looks like Mr. Blazak is the one that signed it. Is he here today? Sorry?
Are there questions, Your Honor?
I don't know. Well, we're gonna need to change the sentencing date, little things like that. But, all right, thank you. So I'm gonna take a quick look here at the PSI. We're gonna obviously turn to CFJ 145, page 1. The court is going to, we need to change the sentencing date. We at one time, we're gonna be here for February 27th. We adjourn that to allow Paul to continue doing any kind of treatment. So change that date. Now, there was no pretrial credit. I forget, was she on a parole? Or why was there?
No, I wasn't. I waived my preliminary.
Yeah, so she would have been in jail for at least almost 2 months. So it looks like we need to calculate some credit there. Was she serving another sentence or anything?
I gotta just look.
I don't see anything here in the court file to suggest that she wouldn't. Can you help us out at all? Do you see anything else for Ms. Hall?
As far as,
Was she serving a other sentence? Saying yes. Hold on, let's take a look at the criminal history here. So she had a case in which she was arrested on September 9th, 2025. We're here for the case for an event that occurred on July 25th of
Yes, and I will
2025.
Right. Your Honor, she had a case in Wexford County at that
Yeah,
point.
she got 60 days of jail. I
Yes.
see that. All right, so that makes sense. All right, so we don't need to make any change there. All right, since we went over the PSI before, I don't think there's any need for correction. Mr. Brinkstrom, do you feel any need to raise objections or concerns?
I don't, Your Honor. I guess I would just be curious as far as the time that she has just recently served. If she was
Yeah.
credit for that.
I want to make sure that we have on her substance abuse treatment on CFJ 284, page 20. Put in there some recognition that she just participated in a program in 2026, January, up at Woman's New Hope. I see Miss Odell shaking her head and,
Agent Blazak is on his way.
oh, okay. All right, anything else that needs to be updated, Mr. Champion?
Not that we haven't discussed, Your Honor.
Okay, great, thank you. All right, so now we're gonna move to allocution, Mr. Champion.
Your Honor, so the court's aware, my client did complete the inpatient treatment at New Hope. She was discharged. The letter that was sent to the parties is that she did well in the program and was doing well in the outpatient portion. She did return to Cadillac to care for her mother, who now has care. Since she's been incarcerated, she has continued her recovery with community mental health. She's met with them several times. With that, Your Honor, she also has a job waiting for her. When she has completed any term this court may deem appropriate. So the court's also aware when she was taken into custody, she did not test positive for any controlled substance, and she's quite proud of the fact that she has remained drug-free in this matter.
That reminds me, Mr. Champion, when did she get picked up? I gotta give her credit. I'm sorry, we need to give her credit for that.
And that's where it gets a little, she would have been picked up, I believe, in
Kalkaska.
Kalkaska on March 12th. The warrant in this case was then issued on the 21st or thereabouts in March.
Yeah, I signed it on March 25th. So I think at the very least, Mr. Blazak has now joined us. Mr. Blazak will have made a couple of changes. Miss Odell was nobody knows. One was the date of the sentence. One was adding her time on CFJ 284 section for her recent treatment at Women's Health. And I now realize we need to give her some credit on CFJ 145, page 2. The court issued a bench warrant on March 25th. It says she wasn't taken into custody until April 21st. But she already had, I had a bench warrant and she got picked up on March 12th or 13th.
Correct.
So we're gonna err on the side of conservativeness and say that she may not have been transferred, but she may have continued to be held on our warrant up in Kalkaska. So we need to do some math.
It'll be 53 days, kind of.
I'm getting 52 days.
It is 53. Your Honor.
53, oh, I'm sorry. Yes, because of March having 31. Thank you. However, that doesn't count today because she already gets credit for today. So is that 52 days, Miss Odell?
It's 53, Your Honor.
53? All right.
Not counting today.
Okay, good. So Mr. Boyd is going to add on that page in the PSI that there is a total of 53 days of credit, which of course will also appear on CFJ 145, page 1. All right, Mr. Champion, I'm sorry I interrupted you, but I didn't want to forget her credit.
You know, my client is very proud of the fact that she has maintained her sobriety and she's learned skills to deal with her sobriety. I would ask the court to consider time served in this matter, and as part of probation, also have her complete the intensive outpatient treatment program. through community corrections.
Thank you very much. Mr. Ringstrom, I'm sorry. Allocution?
Your Honor, I mean, the guidelines are the guidelines in this case at this point in time. I will say for Miss Hall, I mean, she didn't give prosecution any hard time. She owned up to what she did. Since that time, she has done rehab and all that. She's done a really good job, and this is her first drug offense. She's had a lot of thefts and stuff like that in the
Yeah.
past.
That's quite a history.
Of course, it's gonna go through the criminal history and all that, but this is her first real drug offense as a whole. Guidelines are the guidelines. I would say due to Miss Hall's actions after being picked up and doing everything, if anyone deserves a little bit of a break, it would be her. I do agree with Mr. Champion that she would probably have to do some intensive treatment. We will leave it in the discretion of the judge.
I don't recall, is she 7411 eligible?
I don't think she's 7411 eligible. I think that there was something to do originally, we thought that she was 7411 eligible. In the PSI, I think they mentioned something about some marijuana or something a long time ago that needed, so she wasn't.
Yeah, okay.
But originally, we were gonna offer 7411.
I see that. That was 2004.
Yes, correct. Our records did not show it at the time that it came up with the sentencing.
Thank you. Ms. Hall, it's your opportunity to make a statement if you so choose. Is there anything you wish to say before I issue a sentence this morning?
Yes. I just wanted to say that I appreciate the opportunity to allow me to attend rehab. I took a lot from it, and it helped me with my guidance and my structure, and it's good to follow a routine in daily life. And I was very honest about my mistakes that I made. And I just really want to get over this and move forward in a positive way. That's it.
All right, thank you. Well, the sentencing guideline range here is a minimum of 5 to 23 months. While that is not mandatory upon the courts are required to take it into consideration. And it does help establish what may be a reasonable and proportionate sentence. The defendant's prior criminal history is extremely lengthy, and she's of an age where we hope that she should be learning better in her early to mid 40s. One thing that concerns me is, in addition to the number of juvenile and adult convictions, is that substances have been a significant part of her life. We can see that there has been some cocaine use for a long time, up to 26 years, methamphetamine for 23, LSD and their fentanyl, alcohol, and marijuana, although those stopped apparently quite a long time ago. But the more controlled hard substances have been an issue with her for half of her life. The court also notes that throughout her prior criminal history report, there are extensive crimes of dishonesty, retail fraud, breaking and entering, even driver's license suspended is a level of dishonesty because it's doing what you know you're not supposed to do. There's a receiving and concealing property. She's had some issues with operating while intoxicated, breaking and entering into motor vehicles, even assaultive behavior a couple different times, a couple different retail frauds, violations of bond, again, violations of probation. And so it gives the court quite a bit of concern. Apparently, she may have just gotten away with the substances and have not gotten caught. However, she has now participated in a program, and it appears to be, but it does appear to be her fifth inpatient program. She had one in 2024, another one in 2024, and then Great Lakes Recovery. So the court is at a bit of a loss what to do. I don't really know what to do. Got a significant benefit from the case of the prosecutors having dismissed the fourth habitual felony enhancement, which could have made this an up to life maximum, but we're now at an up to 10 maximum. It does, however, also benefit her on the guidelines. She's at a straddle cell. I don't need to come up with many or any reasons to be able to give her even a prison term. So the court is a little bit at a loss of what to do. I'm concerned also that she did not continue with her community corrections treatment when she was released from the program. I thought it was pretty clear. All right. The court places the defendant on a period of probation for 24 months. The court adopts the terms and conditions for that probation that are listed inside the PSI on pages CFJ 145, 2, and 3. The court finds those terms and conditions are well suited for rehabilitative purposes and for the facts in this case and the defendant's prior history of substance abuse. I'll also note that condition 3.3 not only requires potential mental health treatment, but also domestic violence if necessary, and that's consistent with her prior history. The court therefore assesses a $68 state minimum fee, a $130 crime victim right fund fee, a $300 court cost, a $300 attorney fee, a $500 fine, no DNA fee as it was already available. There is a supervision fee of $30 a month or $60 a month if there is any electronic monitoring. The last thing for the court to assess is whether or not a jail sentence would be or is appropriate. And just on the criminal history alone, there's a significant reason to suggest that a period of confinement is appropriate. Also looking here at the guidelines, the court finds that one is appropriate. I will say, however, the court is not going to tip the scale to the prison sentence, obviously because of the probation that I've already announced. Therefore, the court sentences the defendant to a period of jail, and I'll say that I'm also taking into consideration that she did a program, and where I might have typically issued a 300-day jail sentence, the court goes 210 with 53 days of credit. If we're able to get her into a program, the court, of course, will consider an early release if that's recommended by the Department of Corrections. But as of right now, that's the sentence of the court. Mr. Champion, I have the pre-trial advice. Do you have them already?
I do, Your Honor.
Thank you. All right. Mr. Rinkstrom, here's your copy of the PSI. Ms. Hall, Mr. Champion had you place your initials on a copy of the document, and then you're taking one copy with you. This document tells you that you have the right to appeal the conviction and sentence in your case. Now, while this is typically done by filing a claim of right to appeal, if there's been a conviction by a trial, based upon the plea, any appeal must be done by filing what's called an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of that document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Again, the court finds that the sentence today is reasonable and proportionate based upon the factors that I've discussed and those that are contained inside the PSI. Anything further, Mr. Blazak?
No, thank you. Your Honor.
Mr. Ringstrom?
No, you are.
Mr. Champion?
No, Your Honor. Thank you.
Ms. Hall, you've got, you're still young. I mean, 43 is, I think, the old 53 or 63. I don't know how to say that, but you got a lot of hard living. And I would like nothing better than to see you turn your life around. Always reach out to community corrections and always reach, thank you. Mr. Blazak, I would like a part of our term or condition, recommend an EOP program through community corrections. If we could add that as well. I mean, I know it recommends possible treatment in there, but if we can help use community corrections as EOP, I think that would be advisable.
Your Honor, did you stay jail credit when you were?
I did 53 days. Yes, Ms. Hall?
When am I able to talk to Blazak?
I don't know. I'm only in charge of me and these two people over here. Everybody else out there is on their own. So, all right, Ms. Hall,
Thank you.
good luck. Thank you. We are adjourned on that file.
We have Miss Malachi.
Okay,
Do you want to jump?
well, let's